morning. Welcome to the First District Court of Appeal. We have a full house today. Welcome. We've got two cases on our docket consolidated for oral argument. They are Cedric Jenkins versus State 242413 and Chadrick Mitchell v. State 241906. Counsel, are you ready to proceed? And we had 20 minutes set aside for each side for oral argument. Would you like to reserve some time for rebuttal? 5 minutes. So noted. Thank you. You can proceed when you're ready.
Thank you, Your Honor. May it please the court, my name is Justin Karp and I represent both appellants, both of whom had evidence obtained against them because of a wiretap application authorized by the statewide prosecutor. They each filed a motion to suppress, alleging that the statewide prosecutor was not the principal prosecuting attorney of the state under Title III, and as such, the wiretap was invalid. The trial court denied their motions, concluding that the statewide prosecutor was the principal prosecuting attorney of the state for purposes of Title III, and they entered pleas reserving the right to appeal the dispositive ruling on their motions to suppress. So, like any case involving statutory interpretation, I think this case begins and ends with the plain language of the statute. 18 U.S.C. 2516, subsection 2, which is part of Title III as a shorthand, authorizes two prosecutors to apply for a wiretap at the state level: the principal prosecuting attorney of the state in the singular, or the principal prosecuting attorney of any political subdivision thereof, also in the singular. This court's opinion in Rogers from last year tells us that the statewide prosecutor is not the principal of a political subdivision. So really the only question for this court is who the principal prosecuting attorney of the state is for purposes of the federal statute. Now, the disagreement of the parties is whether it is the Attorney General or the statewide prosecutor. And because the Attorney General is the chief legal officer of the state in our Constitution, the office of the statewide prosecutor is a state separate budget entity within its office, and the Attorney General appoints and can fire the statewide prosecutor at will. The Attorney General is the principal prosecuting attorney of the state.
Counsel, let me ask you a logistical question.
Sure.
The Attorney General doesn't have to sign every application, correct? He could delegate that to an assistant Attorney General.
No, as the principal, the Attorney General has to personally approve the wiretaps.
Physically has to do it.
Yes.
He can't have anybody else, under his authority do it.
No, not under subsection 2. Now, if you look at subsections 1 and 3 of the 2516, 2516, 1 and 3, in the federal system, they do allow some delegation. For whatever reason, the subsection 2, which applies to the states, doesn't. And it's, there's plenty of case law out there. I know that, I think it's the Rossello case in the brief, that when Congress includes language in one subsection but not another, we assume that's deliberate.
So your position would be that even though the Office of the Statewide Prosecutor is within the Office of the Attorney General in the Constitution, that doesn't help?
Correct. Because we're looking at the principle. They want to know, Congress wants the most centralized, politically responsive source, and the Attorney General is at the top. Certainly the statewide prosecutor does a lot of functions for the Attorney General. It might be fair to say he's the second highest ranking prosecutor in the state. But Congress used the word principal, and if that means the statewide prosecutor can't do it, the remedy is with Congress, not with this court.
As between Jenkins and Mitchell, the briefs seemed almost identical. Other than the charges, are there any distinction between the argument on either of their cases?
No, Your Honor.
I didn't think so. I just wanted to make sure.
Both dispositive motions, both essentially the same legal arguments. Chronologically, I know the Jenkins case talked about this court's opinion in Rogers, which had been decided, I think, shortly before the sentencing hearing. But in terms of the argument about the principle, I don't think there's any meaningful distinction.
If we agree with your argument, state law has been violated.
Well, federal law.
Well, so that was my question. State law has been violated, and state law has a suppression mechanism. You're correct. State law would not be violated because the statewide prosecutor is authorized under state law to get a warrant, but not authorized
state law violates
under federal law. Right. So I think we're saying the same thing, just different ways. The state law has an exclusionary statute in there. The federal law has exclusionary statutes in there too.
Right.
Under state law, it's pretty clear from the Florida Supreme Court, from Garcia forward, that there is not a good faith exception to this.
That's correct.
Federal law, however, is all over the place on whether there's a good faith exception, and the U.S. 11th Circuit has said that there is a good faith exception. So how do we analyze, if we agree with your argument that the statewide prosecutor was not authorized under federal law to get these warrants, how do we look at what the appropriate remedy is?
I think much like for the definition of principle, you look right at the federal statute, and 2515 says that, no violation of the chapter shall be, let me see the exact language it uses. No evidence whenever any wire or oral communication has been intercepted, no part of the contents of such communication and no evidence derived therefrom may be received in evidence at any trial, etc., if the disclosure of that information would be in violation of that chapter. And even more specifically in 18 U.S.C. 2518 10C, it says that the remedies and sanctions described in this chapter with respect to the interception of electronic communications are the only judicial remedies and sanctions for non-constitutional violations of this chapter involving such communications. So when the statute is clear as to the remedy, the good faith exception is a judge-made doctrine. We don't even reach that when the plain language of the statute is clear. And
moving up right above C, the language you just read, up in A, it lists the 3 grounds on which an aggrieved person can move to suppress. Which one did you argue and move on below specifically?
Well, I believe it would have to be subsection 1 of A, because the communication was unlawfully intercepted in that the wrong attorney had applied for it, because looking at subsection 1 of 2518, 1A, the first thing you need in the application is the identity of who's making the application. And if that's the statewide prosecutor, as it was here, that's already invalid. And, I know it's not binding on this court per se, but the Harris case from the Oregon Supreme Court spends a lot of time talking about the federal statute and, specifically these subsections, talking about why, why the good faith exception doesn't apply here, because, when the statute is clear, we don't get to that second judge-made step.
The supplemental authority, which was the recent opinion on Rogers on remand,
Right.
Dealing with the statewide prosecutor. Judge Neff in that seemed to make a lot of the fact that in a vacancy in office of the statewide prosecutor, the AG acts as the statewide prosecutor if there's not a statewide prosecutor. What is your response to that?
I think in that, again, to be very clear, what Judge Neff was talking about was recognizing that the Rogers opinion still controls as of the subdivision. We're talking about whether they're the principle of the state. We're only talking about that aspect of the statute, the one we're talking about here, unlike in the Rogers case. But I would say that supports the idea that the AG is the principal, because in the vacancy of a statewide prosecutor, AG can act in the Attorney General's stead, but the same isn't true the other way. If the AG is unable to perform their duties for whatever reason, either they or the governor has to pick their replacement. The statewide prosecutor has nothing to do with that calculus. And I think that shows that the AG is one level above, because, they can pick the statewide prosecutor, but not the other way around.
But I think the point of that question is getting to the fact that the statute includes that language that, if there's a vacancy in the statewide prosecutor, then by statute, the Attorney General has the authority to exercise the powers. It's getting at that there's something different between the powers of the statewide prosecutor and the Attorney General. So what's your understanding? Are they...
My understanding is that the
The
Attorney
nature of the
General
AG's
has
prosecutorial
I think
power.
that lends credence to the idea that the Attorney General has more power, because if the one below her is, if there's a vacancy.
But why would they need to put that language in if she has complete power, prosecutorial power? Why would the statute need to state that?
Well, because the statewide prosecutor, it's a secondary petition. The Attorney General already has that power, is already authorized to approve the application for a wiretap as the chief legal officer of the state. Chapter 16 is very clear that the Attorney General shall represent the state in a variety of functions. I think because state law got it wrong, state law is operating under the assumption that Congress allows the statewide prosecutor to apply a wiretap. So when you look at it through that framework, it makes sense that says, okay, well, if the statewide prosecutor can also do this, if they're not available, then the Attorney General can. But that's not a grant of power to the Attorney General. The Attorney General can the Attorney General already has that power by virtue of being the chief legal officer and picking the statewide prosecutor. I mean, the Attorney General could make a vacancy.
Where does
by
the
simply citing-
prosecutorial power come from for the statewide prosecutor? Is it the AG or is it the Florida Constitution, which creates the office?
I would say
defines its jurisdiction?
it's enumerated in the Constitution, certainly as a separate budget entity within the Attorney General's office, but I think the authority comes from the Attorney General.
But
I
it
mean-
says this in the Constitution, the statewide prosecutor shall have concurrent jurisdiction to prosecute violations. Is that granting the prosecutorial power for that jurisdiction?
I think it's recognizing that the statewide prosecutor can work on behalf of the Attorney General as an agent. I think, certainly, there was a lot said in the briefs, and I believe at the last oral argument on this issue last year in Michael Wallace's case, it's not the Attorney General going to court and taking the depositions and doing all this stuff. And that's fine. We're only talking about the wiretap authority because that's what Congress has an explicit limitation on.
State cites the old Fifth Circuit, U.S. Fifth Circuit case, Pachinko, and talks about having a centralized, responsible authority, and contends that the statewide prosecutor fills that role. What's your response to that?
I think it's fair to say it is a centralized, but the responsiveness is, and I think this is why it's so important to focus on the text, because Congress used the word principal, singular. So who is the principal? Who is the highest? That is the Attorney General. The statewide prosecutor, it seems it's organized somewhat similarly, but it's a step below the Attorney General. So that's really what matters. By the state's own definition in the briefs, the statewide prosecutor is one step removed from political accountability, because they say, if the statewide prosecutor is abusing this power, then the Attorney General, they can be removed by the Attorney General, who's responsible to the voters. And I think that kind of gives up the game, because it's like, well, the accountability is through the Attorney General, which I think just makes the Attorney General the principal. It recognizes that. And if there are no further questions, I'll reserve the remainder of my time for rebuttal.
Thank you, counsel.
Good morning, Your Honors, and may it please the court. Alan Huang for the state. I think I'd like to start by noting that what the defendant's position is, he speaks of as textualism, but I think it veers into a narrow formalism that doesn't really get at the inherent flexibility in the words of the text, in the words of the text of Title III.
Is the word "the" flexible? When you talk about the principal prosecuting attorney, is that not singular?
Sure, I think, well, two things. One, Daniels, which is binding on this court, has told us how to interpret Title III, and it said that, this concept of the principal prosecuting attorney of a state or political subdivision is getting at centralizing the power in a narrow class of officials who are centralized and politically accountable, and we believe that statewide prosecutor fits that bill.
Would you also agree that the word principal normally implies one singular entity, a person, a unit, the head authority? I could probably give you the OED definition. First, in order of importance, according to the Oxford English Dictionary.
Sure, in terms of centralization, and we believe the statewide prosecutor, as Judge Norby pointed out, his vast powers pointed as enumerated in the Constitution and in Florida Section 16.56 shows that, in context, that whole phrase, principal prosecuting attorney, it's getting at that the state's prosecutorial power.
And then lastly, an attorney is into 18 U.S.C. 2516. Attorney is also singular, not attorneys, which you're reading attorneys into that, even though it says attorney, right?
Well, two things. One, as I mentioned, I think Daniels has a lot to say about this that would be binding about what Title III is getting at, and related to that point, I think all this court needs to do is to look at the position before us whether the statewide prosecutor is, whether it's the or a principal prosecuting attorney of the state, that he fits the bill, that he's centralized and politically responsive to the political process. And if he is, the court can just affirm and leave for another day kind of the attendant questions, or how a holding like that would be interpreted in the future cases.
The Constitution makes the Attorney General the chief legal officer of the state of Florida. In some federal cases in Dome, I think, from the U.S. 11th Circuit, they said the Attorney General is the principal prosecuting attorney. So are you saying that there can be more than one principal prosecuting attorney of the state of Florida? That both the AG and the statewide prosecutor are the principal prosecuting attorneys of the state?
I mean, I think all this is in the context of the wiretap power. And if we look at the state statute, it lists several officials, and you know, our kind of, I guess, background position is that statute as a whole is not, you know, it conforms to federal law. It's not conflict preempted. But as to the question just before us, whether the statewide prosecutor is the or a principal prosecuting attorney of the state, I think we're just saying that he meets those criteria.
Would you agree that the Attorney General directs the statewide prosecutor can set the priorities, so the statewide prosecutor can tell the statewide prosecutor to investigate a particular issue?
Sure, that's possible, but at the same time, it's directly from the Constitution and statute that statewide, the vast powers to investigate and prosecute crimes at the statewide level is vested in the statewide prosecutor.
What I struggle with in this case, we have, you know, two federal circuit decisions from the 11th Circuit and the 5th Circuit, and they really focus on the intent behind the language and the purpose of the language. And I'd really like to hear from the state. You know, you're from the AG's office. What is your best textual argument supporting the position that the statewide prosecutor is the principal prosecuting attorney?
Sure.
No intent, no purpose,
Mm-hmm.
language.
Sure. Well, the phrase is not just principal attorney of the state, it's principal prosecuting attorney. And if we match that up to like all the powers given to the statewide prosecutor in section 16.56, it basically gives him all the powers that state attorneys have in their circuits, in their political subdivisions, and he has all that power at the statewide levels, and I think that makes him you know, the or a principal prosecuting attorney of the state. Certainly the Attorney General appears in all, you know, civil and criminal cases for the state, but in terms of doing the actual prosecution, you know, that's vested. The Constitution and the statutes vest that in the statewide prosecutor.
One of your arguments was the statewide prosecutor is a centralized, politically responsive source. Then, how is that any different than you know, you or the Solicitor General being a centralized, politically responsible source, or any other you know, Assistant Attorney General? Aren't you all answerable ultimately to the AG, so that he or she is the centralized, politically responsive source?
Sure. I mean, let's say the head of any other division in the office wouldn't be a principal prosecuting attorney. They might be the principal of some other office. And in terms of just having that power, whether that power somehow is kind of given to any kind of line attorney, that wouldn't meet the criteria of being centralized and politically responsive, because the power would be so diffused, and there could be an argument if the power is abused that the line attorney or was acting out of bounds. But here, the position of the statewide prosecutor, he's one person given all that power in the text of the Constitution and the Florida statutes. So it makes him centralized, and if there is a abuse of the wiretap power, he's that identifiable person who we would know is responsible and is tasked with using that serious wiretapping power even-handedly, and if he abuses that power, then to use the language of the cases, the lines of responsibility lead to him, and from him to the elected Attorney General, and so the statewide prosecutor would be might become a political liability, and the Attorney General could.
Well, I mean,
could
isn't that the
remove
same
him.
though, for any assistant state attorney? You know, if assistant state attorney bungles a prosecution of a murder case, you know, the people of that circuit are going to be upset ultimately with his or her boss, right? The state attorney for the Second Circuit. But the ultimately politically responsive one is the state attorney in my hypothetical, or the AG in the case of the statewide prosecutor, right?
Well, it wouldn't be centralized, but say, but as to the statewide prosecutor, that is a centralized position. If any, like as I mentioned, if any line attorney messes something up, you know, there's so many layers there that it's not necessarily. It doesn't, to use the language of the case, the conduct there doesn't lead necessarily to one person, and for prosecution at least on that, for that in that arena, it's the statewide prosecutor who prosecutes on behalf of the state at the statewide level.
Your secondary argument is, even if we disagree with you on the principal prosecuting attorney, the good faith exception, U.S. v. Leon applies. Under state law, starting with State v. Garcia, 1989 Florida Supreme Court case, which was post-Leon, the Supreme Court of Florida and the various district courts that have analyzed it have said there's no good faith exception to Chapter 934. However, federal courts they're mixed, but they have said that there is a good faith exception to the federal exclusion. So how do we analyze this? Are we looking at this under state law or federal law?
It would be under federal law, and we think the courts that believe that the good faith exception applies to Title III have a better of the argument. That at the time Title III was enacted, Leon was not around, but Elkins was, and it had a form of the good faith exception. And so when Congress enacted Title III, it brought along with it that the soil and that concept, so Title III could reasonably be interpreted to include at least the judicial developments at the time it was enacted.
In looking at 934.06 in about 10 years ago in McDaniels v. State, the Florida Supreme Court said we must give the statutory language its plain, ordinary meaning, and not at liberty to add words that were not placed there by the legislature. If we find an exception to the exclusionary rule under the federal statute, are we violating the Supreme Court's Florida Supreme Court's dictates from McDaniels?
I don't think so. I mean, I think we're looking at the federal statute, and which is not purely a direct violation of something in 934. I think the court could reasonably find that the good faith exception applies. I meant to conclude, we just don't believe that when Congress was enacting Title III that it meant to preclude someone like the statewide prosecutor, who, as I mentioned, has powers over investigation and prosecution at the statewide level, that it meant to preclude someone like him from authorizing wiretaps. The point was to take us away from that time where any line attorney could authorize wiretaps. So we think his position is in line with the text and what Congress was doing there, and we'd ask the court to affirm. Thank you.
Thank you, counsel. Rebuttal.
Just have a few quick points on rebuttal. To the state's contention about formalism, the framers of the Office of the Statewide Prosecutor, the Palmer article cited, to the extent we're talking about purpose, like Judge Norby's question mentioned, of course it's always grounded in the text. I think we win on the text of the federal statute alone. But, I think when you look at, the purpose, they weren't blind to the possibility that having the Attorney General approve the wiretaps, could be a burden that they were okay with. That's discussed in the Palmer article. You know, I think the committee report for the federal statute that the state cited, you know, talks about that in most states, the attorney general is going to be the principal prosecuting attorney. Of course, Congress isn't going to enumerate 50 different principles. They're going to leave it to a matter of state law. But they said it doesn't envision a further breakdown. So, you know, certainly there are points to be made about the, you know, is the statewide prosecutor identifiable and centralized? But when we're talking about the principle with no further breakdown at the federal level, the real question is there someone higher? For the statewide prosecutor, the answer is yes. For the attorney general, the answer is no. So, you know, I think that's really the question for this court. As Judge Bilbrey mentioned, it's all, the language Congress used is all in the singular. So is there someone higher? And
Well,
you know,
and then how do we square then even the attorney general being authorized to approve warrants with U.S. v. Pachinko, which of course is not binding on us, it's a federal case.
Mhm.
But there they said that the governor is superior to all prosecuting attorneys and can authorize wiretaps.
you know, that one is sort of an outlier, but I believe that was before Dom, and which is now the 11th, because it was then the 11th Circuit, and there hasn't been anything since Dom receding from the idea that it's the attorney general. And you know, with the good faith exception, I would just point to the discussion.
But Dom predated the creation of the statewide prosecutor in our state constitution, so that is
correct, but
worth
I don't
noting.
think the addition of the statewide prosecutor to the state constitution doesn't change the fact that the AG was already and still is the chief legal officer. Because again, we're looking at in terms of hierarchy, they're not parallel. The AG
But
is
in our constitution, we've created a specific statewide prosecutor with prosecutorial power, so it is, you know, there.
Well, I mean, I think, you know, looking in the full context, you know, the statewide prosecutors, yes, they're named in the Constitution, but if you look at the structure in Chapter 16, they're in the Attorney General's office, and the Attorney General picks them. You know, I think that's a pretty clear example of, as the state was saying, going to court, prosecuting these cases, doing all these things, like that's an agent acting on behalf of the principal. The statewide prosecutor can't tell the Attorney General, hey, I want you to go ahead and try this case, but the opposite is true. And just one final point, unless the court has other questions on the good faith exception, the Harris opinion from Oregon, it does talk about post-Leon cases from the U.S. Supreme Court. It was a different subsection. I believe it was DAHER. It was discussed in the Harris opinion, talking about how they, you know, didn't apply the good faith exception when talking about Title III. It wasn't the same subsection we're talking about here. I don't remember the exact issue. But, you know, they have declined to apply the good faith exception in the wiretap context. The U.S. Supreme Court, it was, I believe, a 2018 case that was discussed in the portion of Harris cited with this court. And if there are no further questions, I will waive the remainder of my time.
Thank you, counsel. We appreciate the concise argument from both sides. And with no further business before the court, we are adjourned. Thank you.